Hello, welcome to Module 6, where we're going to talk about national bank preemption. And as you might remember, we talked about bank preemption in the context of McCulloch versus Maryland, when the U.S. Supreme Court determined that states could not enact laws that would destroy something that Congress created. And this really came to a head in 1996. There had been a lot of, let's say, legal debate as to the scope of national bank preemption, but we were starting to see national banks operating across state lines. There were some law changes in 1994 that allowed that to happen. And so by 1996, a law had made its way up to the US Supreme Court. And the bank, the national bank, and we're talking about national banks today, was trying to stop the Florida Department of Insurance from prohibiting bank employees from acting as insurance agents in small towns. And the reason that this is a preemption case is because there is a section of the National Bank Act, Section 12 U.S.C. 92, that expressly authorizes national banks and consequently their employees that are operating in small towns, those not exceeding 5,000, to work as insurance agents and selling property and casualty insurance. The thing to know is that agency means selling, so they're not insurance companies, they're merely selling. And I can only imagine that this law was enacted in response to a need at some point. Some point they must have needed more insurance agents, and so Congress enacted a provision expressly allowing this to national banks. As you can imagine, there became a debate over what this meant about towns that exceeded the 5,000, and it was ultimately determined that it meant national banks could not act as insurance agents in those larger cities. So this is only in the small towns. And this is how the law was for quite some time until Florida happened to enact a law that expressly prohibited bank employees and banks to operate as insurance agents in Florida. And the way that they wrote this, they wrote it so that if it was a small town bank, it would still be permitted. But if it was a branch of a larger institution, it would be prohibited. But the way the federal law is written, it is prohibited at any branch in a small town. And so this large national bank decided to challenge the Florida Insurance Agency. And something to know is that insurance is state regulated. So as we will learn, banking is both state and federally regulated, and there are state banks and federal banks. Insurance is regulated on a state-by-state basis, and we're talking about property and casualty insurance, not health insurance. Very little regulation of insurance at the federal level. And so this Barnett Bank case, which is one of the most important national bank cases, discusses the different types of preemption that exist for banks and really for all types of institutions or laws. And the first type of preemption is express preemption. And that means that Congress enacts a law that says, here's the law on this topic. It preempts state laws on the same topic. And we will learn about some laws like that. But that's not what we're dealing with here, because Section 92 doesn't really talk about state law at all. The second type of preemption discussed in the case is this pervasive federal scheme. We're not going to talk about that because Dodd-Frank Act abolished that type of preemption. And then the third and the most common type of preemption that reaches the courts is conflict preemption. And within conflict preemption, there are two types of conflicts. One is irreconcilable, and the other stands as an obstacle. So for irreconcilable, it would be if federal law said all national banks must operate as insurance agents in small towns, and Florida law said none can operate as insurance agents. That occasionally happens, but most often when cases get to court, they talk about this conflict preemption and that the state law stands as an obstacle to the accomplishment of an objective of Congress in enacting a federal law. And so this is exactly what the US Supreme Court was looking at Was the Florida law standing as an obstacle to the accomplishment of an objective that Congress sought to achieve with the federal law of Section 92? And it doesn't seem particularly difficult to determine that, yes, by prohibiting something that Congress allowed to national banks, state law was standing as an obstacle. But what's really important, and what is the standard today, and what the court said in 1996, is that Congress would not want states to forbid or significantly impair, or impair significantly, I guess is how they said it, the exercise of a power that Congress has explicitly granted. And so that is basically the standard, that state laws that forbid, of course, but most often it's the question of, does the state law impair significantly? Because again, once we get to something that's more gray, there is more debate. And so I want you to think about, as a compliance professional, are these the kinds of decisions you would be comfortable making? Do you feel able to determine whether a state law impairs significantly a power granted to your bank, if that's your role? Now, there's something else that was talked about in this case that I do want to just touch on, and that is this anti-preemption rule called the McCarran-Ferguson Act. And that was enacted in response to applying federal antitrust laws to insurance. And one of the reasons I want to talk about this is because you may already realize that insurance and banking seem to conflict a lot. There's, for some reason, been a certain level of animosity between the banking industry and the insurance industry for a long time. And because the insurance industry was very unhappy that federal laws were being applied to insurance, which is considered an area of state regulation, they got this law enacted that said the business of insurance shall be regulated by the states. But because of our federal system, there was also a provision added that basically said, unless Congress wants to regulate insurance, and then they may, but they must specifically state that they're regulating insurance. So what this law says at the end of the day is that general laws don't apply to insurance, but Congress is free to enact laws that specifically regulate insurance. And so in some ways, it's a symbolic law to establish that in general, states regulate insurance, and that does continue today. But if we think about the dispute before us in this case, this Barnett Bank case, it was easy to determine that this federal law specifically regulated insurance because it specifically discusses insurance. So we get back to the point that it significantly interferes with an activity that Congress has authorized for national banks in small towns, and so it preempts. And so this might give you an idea, if you at all watch the sort of the whole fintech and a lot of different things going on, this gives you an idea why banks are so important and so many businesses, because they do have this ability to not comply with certain state laws, this federal preemption, because as the cases say, they are national favorites and states cannot regulate them in a way that interferes with the powers granted by Congress. So this continues to be an issue today, as you can imagine. When a bank and its compliance department is deciding what laws to comply with, it can think, is this a state law we must comply with? Or is this a state law that is preempted? So it's a very important issue in compliance circles. And in fact, there is an ongoing current debate about escrow laws. And this is in your book, but there's some of it is still going on today. And so the case in your book dealt with California's escrow law. And California has a law that says if a lender, which could be a bank or it could be a non-bank, requires a borrower to get an escrow account to put in their payments for insurance and taxes typically, and it sits in an account and then it's paid out by the lender, that account must pay interest, because traditionally these accounts were sitting in non-interest bearing accounts. So that was not beneficial to the consumer. So California, as we will see, a consumer friendly state, a state with a lot of consumer protection laws, passed a law that said these escrow accounts must pay interest at 2%. Well, Bank of America looked at this and they said, we're a national bank. We don't have to comply with this. We looked at this issue. We don't want to comply. And so that was the question. Does this apply or does it not? Well, what's kind of interesting here is that we see that the California court, it was the Ninth Circuit, a federal court, said it's not preempted. They said you can go ahead, you can make mortgage loans, you can require escrow accounts. Paying 2% interest does not interfere with your powers as a national bank to carry on the business of banking. But a few years later, we see a similar challenge, very same bank, Bank of America. They're also not paying interest in New York. And New York, another state that's fairly consumer friendly, also requires mortgage lenders to pay 2% interest. But what's interesting is that when Bank of America goes to court in New York, the New York court says, yes, this does interfere with your banking powers. Making mortgages is part of the business of banking, requiring escrow accounts, part of the business of banking, and New York can't go in and tell you to pay interest on those accounts, and so the law is preempted. Now, the California case was appealed to the U.S. Supreme Court, but the court said they would not hear it. But after the New York case, we had a split. One court says preempted, one court says not preempted, and so the U.S. Supreme Court has agreed to hear it. So this is an open issue right now. But it does give you a sense, I hope, of how these are not black and white. Even though we have a pretty strong body of law on preemption, there are still differing opinions, both by the bank and their compliance departments and by federal courts. So to give you just some other examples, and these are all prior to the enactment of the Dodd-Frank Act, and that will become important in a moment. But there was this period of time where there were a lot of challenges to states relying on preemption. So we see here, this was in Texas. There was a rule in Texas that said a bank could not charge a fee for cashing a check. Typically, a bank will charge a non-account holder a fee if they come in to cash a check. And Texas said that's prohibited. And the bank said, we're a national bank. We can charge any fees we want. And the court said, you're right. Check cashing is part of the business of banking. You can charge any fees you want. Similarly, in the Ninth Circuit, there was a law that said that certain disclosures were required. And this national bank, Chase, big bank, said, we're a national bank. We're allowed to lend through credit cards, and we don't have to comply with your disclosure statutes. And the court agreed. Credit card lending is part of the business of banking. The state can't regulate that. And in the Sixth Circuit, that's where we are in Ohio, there was a law that dealt with fees on garnishment, and it prohibited those kinds of fees being charged to individuals' accounts. And we had a national bank that says, hey, garnishment is part of collecting on lending, which is part of the business of banking. And so we don't have to comply with these prohibitions on fees because we have national bank authority. And the Sixth Circuit agreed. And this was pretty much the way things were going. Now, if you look at these dates, you see we're leading up to and into the actual financial crisis. And there was, of course, a lot of finger pointing and blame, but there were some that said some of it was the fact that these banks were so big and they were not complying with state laws, particularly state consumer protection laws, because a lot of the problems that led to the financial crisis in 2008 did relate to consumer borrowing and consumer lending. And so in the Dodd-Frank Act that followed the financial crisis, the Congress put into federal law that the preemption standard for national banks is out of this Barnett Bank case, and that the standard is, does a state law prevent or significantly interfere with the exercise of a national bank with its powers? And so there was debate as to whether this is a restatement of the law that everyone agreed upon, or whether this was a signal that the courts and the banking regulators and the banks were going too far. You can take both sides of it. I think it was a little bit of a slap down, but as we'll see, it doesn't seem to have made a lot of difference. But this is now in federal law, making clear that Barnett Bank is the standard. This is written in terms of consumer financial laws and consumer credit, but it actually applies to all types of lending and all types of bank activities, because this Barnett Bank standard, and this prevents or significantly interferes, is the standard that the courts and the banks use themselves. Now, after this date, the OCC amended its rules on preemption because it had used different language, and that's actually why I do believe that the provision that was enacted in Dodd-Frank was actually sent as a message to the OCC. And so the OCC amended their rules to say that the standard for preemption is the Barnett Bank standard. But in this same regulation, the OCC gave a bit of a list. And they did list the types of laws that aren't preempted. So this is important to understand as a compliance professional, that as a bank, a national bank, you still must always comply with general contract law and tort supply, criminal law, debt collection, property laws, how you get a mortgage, taxation, zoning. Basic laws of general applicability apply to a bank. So a bank cannot avoid any of the general laws that we see apply to all businesses, because none of these laws really interfere with the business of banking. I mean, I guess debt collection could be questionable, but it's been established that it does not. What's the difference between loan servicing and debt collecting? That's a question that is open. But it is a reminder that as a national bank, there are plenty of state laws that do apply. The regulation then goes on, though, to list the types of laws that a national bank does not have to comply with. So a state cannot require a national bank to get a license. It cannot interfere with the ability of a bank to ask for insurance on collateral. It cannot interfere with loan to value ratios. It cannot interfere with the terms of credit, the repayment schedule, amortization, minimum payments. It actually says escrow accounts. That is part of what the national banks were relying on. Securities, credit reports, disclosures. This is a pretty exhaustive list. Now, this is the OCC regulation. And as we see, Bank of America relied on this not to comply with an escrow law in California, and the court said it was wrong. So this is a regulation. It's a pretty aggressive position that the OCC has taken. So, you know, I guess you can rely on it at your peril, but I think it does give a good sense of what laws and what types of laws are likely preempted or not preempted. And so this is a huge benefit for national banks. And it is why we will see, and we have seen, that all the largest institutions are national banks, because they have this Barnett Bank preemption, which applies only to national banks. We're going to go on and talk about state banks. State banks do have some level of preemption, and so they're not without preemption, but they do not have this Barnett Bank preemption. So if you have questions on this topic, please feel free to reach out to me, but it is a very important topic for compliance professionals. Thank you.